This is Arbin Phrase Review 1 at 200 words per minute. Ready? Ladies and gentlemen of the jury, the defendant in this case is presumed innocent until proven guilty. This presumption of innocence remains with the defendant throughout the trial unless you have a reasonable doubt. If you cannot find him guilty beyond a reasonable doubt, then you should find the defendant not guilty. Members of the jury, the plaintiff alleges, makes the allegation or claims in his complaint that he was injured, that he suffered an injury because of the alleged incident. As the jury, it is your duty as jurors to listen carefully while you consider what happened and whether the contractor who breached the contract is at fault. You will hear testimony about the scene of the incident, what happened on the day of the incident, and many details about the date of the incident. Do not confuse the day of the incident with the date of the accident, the scene of the incident with the scene of the accident, or the day of the accident with the date of the incident. Remember that the accident and the incident are two different incidences. At the time of the accident, the defendant was operating his motorcycle and the plaintiff was operating his motor vehicle. This has been stipulated to by both parties. The stipulation has been made, so keep in mind the circumstances of the stipulating situation. We have seen a computer simulation of the accident. While it was not an overstimulating presentation, the opportunity to present the simulation is ruled as necessary at present. Now, the plaintiff has a history of filing lawsuits, and you may take that into consideration. You may consider his frivolous history of lawsuit filing. I can't say that the plaintiff committed any wrongdoing. For all we know, he may have been injured in previous accidents, and perhaps none of them were filed frivolously. The plaintiff was questioned about his previous filings, and we learned about his history of accidents. We know that he was driving eastbound when a northbound semi-truck caused a collision with his Toyota. We know that an ambulance was called to the scene of that accident, just like what happened at the scene of this accident. When the paramedics arrived at the scene of the accident, after the accident, the plaintiff claimed that he hurt his neck, that his shoulder was bruised, his ankle was sprained, and he suffered from headaches. He was taken to the emergency room at General Hospital by the ambulance paramedics and operated on for his headaches. He sued the driver of the semi-truck for causing the accident and the doctors at General Hospital for trying to perform a fictional procedure, a headacheectomy. The plaintiff was left in the recovery room for too long to recover, while the revolving shift nurses disregarded his well-being. Without adequate supervision by a member of the nursing staff, he claimed he attempted to exit the hospital via a revolving door, which as it revolved slammed his other ankle, completely obliterating the bone as if shot by a revolver. The foreman knows he alleges that the hospital was incompetent for not having proper supervision of patients after anesthesia. These improperly supervised patients should have had doctors, nurses, or at least an orderly to supervise their recovery in a proper way. Because these injuries happened on hospital property, the plaintiff claimed negligence on the hospital's part. The foreperson knows he claimed that there was no contributory negligence, that he was not contributorily negligent because he was under the influence of medication and should have been deemed a risk. During the time that he was in the hospital, the plaintiff realized that he needed the nurses to do everything for him. They clothed and bathed him, but badmouthed him as he breathed in a labored way. He then claimed he was bitten by a buck-toothed infant birthed just down the hall. He soothed the buck-toothed baby as he smoothed the blanket, and the little boy teethed on his casts. The plaintiff insists that the jury resists basing their verdict on if the problem persists. That, of course, is all in the past, and happened before the accident. 2 years after the accident, or in 2005, the plaintiff was involved in another accident. This time he was rear-ended in the fender by a robot named Bender. He claimed this collision bent his car's frame and caused whiplash, due to how surprised he was once he analyzed the situation. He was taught to analyze everything, to give more than a partial analysis. The forelady realizes that as a result of the accident, the plaintiff complained of lumbar pain and a missing cervical disc. He sued Bender and the quack of a chiropractor that tried to find his missing disc. He claimed that the chiropractor worsened the condition caused by the collision by performing incorrect procedures rather than proper ones. He claimed the chiropractic care he received was inconceivable. He was treated improperly, and the impropriety the chiropractor showed was unnecessarily brash. The other lawsuit the plaintiff filed involved alleged harassment by law enforcement. He claimed that he was stopped and frisked by a police officer. The policeman did not have probable cause to search his person, and neither did the policewoman. The Internal Affairs Division claimed there was no wrongdoing on the part of the officers, except that they informed the plaintiff that he was not free to go. As he was not being detained, he should have been informed that he was free to leave. He was instead taken to the police station by the detective, sergeant, and patrol officer from the City of Springfield Police Department. The police officers were disciplined because although they are allowed to lie in the course of their duties, they are not allowed to commit the offense of false imprisonment. After the incident, the plaintiff filed a lawsuit alleging harassment both before the incident and after the incident at the scene of the incident. Wednesday is the day of the week this allegedly fell upon, and it was witnessed by several witnesses. One witness saw the occurrence from his rear-view mirror, another witness observed the incident in his side-view mirror, the third witness had a clear view through the windshield of her automobile, even though the vehicle was parked on the other side of the street. She was unfamiliar with the area and was stopped because she was being ticketed for not wearing her seatbelt and talking on her iPhone while driving. The police officer asked to see her driver's license, but she had only a pilot's license, fishing license, and her FOID card. She claimed she was wearing her seatbelt, but the officer couldn't see it because it was the same color as her blouse. She then severed all ties with that blouse due to the severity the ticket would have on her insurance rates. She told the cop that she was using her GPS, not talking on her phone, but the officer wrote her a ticket regardless.